Hi, and welcome back. This week we are talking about civil liberties, which corresponds to chapter 4 in your textbook, which you should read for our civil liberties reading this week, as well as watching the video of Constitution USA about civil liberties that is posted on Blackboard. Civil liberties are your protection from the government infringing on your rights as a citizen. So these were actually pretty novel when the United States was first founded. The idea that in writing, the people, the citizens, needed protection from the government. Now, in Britain, there were some, and they had been developing for hundreds of years. But when the Bill of Rights was ratified in 1791, just after the Constitution was ratified, these were revolutionary in every meaning of the term, right? Because democracy, the way that we know it, and civil liberties are actually in inherent conflict. We call, around the globe, we call most modern democracies, we call liberal democracies. Not because they're progressively liberal in the sense that we talk about liberal in the United States, but actually is quite a different meaning, that they incorporate liberties, meaning that the citizens have protection from the government. So why is democracy and civil liberties inherently in conflict? Well, because in a democracy, the people, the majority, can do whatever they want, just like a dictator could, or a king could be able to do whatever they want. Laws could be passed, whatever the people decided as a majority they wanted, they could do. And so you can imagine in the United States, if the majority felt like the right to own guns was no longer a good thing, we could just majority pass a law that restricts the right to gun ownership. Well, instead, we have the civil liberty enshrined in the Second Amendment that has includes the right to bear arms. And so that liberty is protected. And so these are in conflict because in a democracy, there are things that we can't vote on. There are things that the government, acting for the people, cannot do. And this particularly protects minority rights in a majority rule society. So if you have something unpopular to say and people want to stop you from saying that, in a pure democracy, laws could be passed that stopped you from saying it. But in a democracy like the United States, where we do protect freedom of speech, even unpopular speech is protected, even offensive speech is protected, even horrible speech is protected. And we will talk about that more in the next video in free speech. But keep that in mind, that this is intended to protect people who have unpopular opinions, people who participate in unpopular religious ceremonies, people who aren't necessarily approved of by the majority. Because if we allowed the majority to make all the decisions, we would not be a liberal democracy. We would not have civil liberties. It would just be a standard democracy where the majority rules. Our civil liberties are protected in the Bill of Rights. This is the first 10 amendments to the Constitution. And you'll remember from the beginning of our course that the Federalists argued that the Bill of Rights was unnecessary and even dangerous because listing our civil liberties inherently restricted them. In hindsight, in the hindsight of 200 years, I think we can look back and say that their argument was wrong, and that in fact, civil liberties have only grown and grown and grown since the time the Constitution and the Bill of Rights was ratified. You'll note that the Constitution itself, without the amendments, did protect a few civil liberties like habeas corpus, bills of attainder, ex post facto laws, and trial by jury, and the fact that treason doesn't convict your heirs. But these are small in comparison, important, but small in comparison to the number of rights that are enshrined in the Bill of Rights and have continued to grow since the ratification. So what is in the Bill of Rights? You don't need to memorize all of these, and we're primarily going to focus actually on the first amendment here. But I think that it's important to note that we not only have the freedom of speech and press, assembly, petition, and religion all enshrined in the First Amendment, but also the right to bear arms, the protection against having to quarter soldiers, right against search and seizure. You have the right to due process of the laws. And then you have several here at the end, 6 through 5, 4, 4 through 8 here, forgive me, 4 through 8 here that are all about criminals' rights, or people who are accused of committing a crime's rights. And I think that if you think back to some of the events surrounding the founding, including the institution of martial law in Boston, this will make sense to you. Because if the government can accuse people of crimes and conduct a swift and private trial and convict people and punish them however they want, that is a recipe for a dictatorship, for abuse of power. And so our Constitution details different ways that United States citizens are protected when they've been accused of a crime. And all of these help United States citizens be treated fairly and equally by the United States government if they are involved in the criminal justice system. So, and then also you'll note that no quartering of soldiers is also probably fresh on their mind from the events surrounding Boston and other places where soldiers were forced into people's homes to monitor them, and that was called quartering of soldiers. And this is really one of the first places where we're talking about not protecting citizens from government surveillance, that and the Fourth Amendment. But in this video, we are going to primarily be talking about the First Amendment. It has a lot of protections from government infringement in this First Amendment. So it reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. Now, this is a lot, as I stated, but they are all tightly related to one another, and that is why they are all in one single amendment. This is all protection of your ability to have a belief or an opinion and to express that belief or opinion however you see fit. So you have the right to believe in your religion without the government telling you what to believe, and then you have the right to exercise that religion. You have the right to believe what you want and say it out loud, or to write it down and publish it. So that's speech or the press. You also have the right to get together with other people who believe the same thing you do, and to talk with them and to associate with them. And then you have the right also to petition the government, to tell the government what you think. So this is all about freedom of expression. And so that's what the First Amendment really is. The first one we're going to tackle in this video, we're going to do religious freedom. And in the second one, we'll be talking about freedom of speech. But for the purposes of this video, we're going to talk about the phrase, Congress can neither make a law establishing religion or restricting the ability to practice your religion. So, religious freedom is from the establishment of a church of the United States. The government cannot establish a church or require a religious test or affirmation for public office. Now, before the Civil War, when states had substantially more rights, this was actually only a protection from Congress doing this. If you go through the Bill of Rights, it might start making sense. Congress shall make no law. Congress shall make no law. But what about North Carolina? Can North Carolina make a law that establishes a church? Before the Civil Rights, before the Civil War, the answer was yes. But the 14th Amendment started a pattern of states also having to adhere to the Bill of Rights as well. And that was a long process, but now it does apply to each of the first 10 amendments. So we can say now that the freedom of establishment from religion is firmly rooted in both state and Congress, federal, against that from the state and Congress. And so for the freedom of establishment, for example, the court has consistently determined that school-sponsored prayer, Bible readings, or religious services at schools violates the First Amendment because it is an establishment of religion. Well, if the court is making these rules and they're not necessarily enshrined specifically in law that describes the Constitution, because you know that the court is the Supreme Court is the highest interpreter of the Constitution, how do we know, or how do people who run public schools know what violates the Constitution and what doesn't? How do they know how the Supreme Court would rule? And you know that the Supreme Court operates by precedents, so that's what people who are making these decisions also have to think about. And the way they make this easy to apply precedent, or easier, I suppose, is to establish tests. The Supreme Court and other courts almost always, for big cases like this, are going to establish tests that they can apply in the future. So for example, for the freedom of establishment, they've created the Lemon Test. Now this is a little bit outdated, but it's a great place to start. It's been updated, but this is where it started. The Lemon Test states that a government action must have a secular purpose. So right here, please note that secular means non-religious. So the government action must have a secular purpose. It must also have a predominantly secular effect, and it must not foster excessive entanglement between government and religion, meaning that the government and religion shouldn't have too much interaction. It shouldn't be too closely interactive through whatever government action this is. So we have these three things that all three have to be true, that the law has a secular purpose and secular effect, and it can't have excessive entanglement between government and religion. So I'm going to give us a chance to, I'm going to give us a chance to apply this test through this video. We'll do it independently, but I'm going to give you a set of facts, and then I want you to pause this video, and I want you to write your answer to whether it has a secular purpose, has a predominantly secular effect, and does not foster excessive entanglement between government and religion. So here's the set of facts that's coming to the court, and you are the Supreme Court Justice. The state of North Carolina has decided that they want to subsidize all teachers' pay by giving even school teachers at private schools a raise when they teach secular subjects. So for example, if you're in a private school here in Cullowhee and you teach math, you would be given a government subsidization in your check. They would send you a check for teaching that class. And you can imagine other teachers might be teaching history or political science, or I suppose in public school it'd be civics, or any number of subjects, as long as it's secular, meaning a non-religious class. And the government's going to pay those teachers more money to teach those classes. So right now, I want you to pause the video and think about it for a few minutes, and then I'll go one by one through each of the prongs. Okay, I hope that you paused the video, because on your exam, I'm going to give you a similar set of facts for you to reapply, so this would give you some practice. But right now, I want to go through all of these and talk about which ones the court thought passed and which ones the court thought did not pass the Lemon Test. Sorry about that brief interruption. Let's see. Let's get back to this North Carolina law and whether or not it passes the Lemon test. So hopefully you've written down which prong you think it violated, or prongs, or maybe you think it passes the Lemon test. Let's go through with what the court thought. Does the law or the government action, the subsidization of teachers teaching non-religious classes, does it have a secular purpose? Well, the court said, sure. The purpose is stated that that it has a secular purpose because they're funding secular education. That's the purpose. Does it have a predominantly secular effect? Why not? It has a predominantly secular effect because teachers are being encouraged to teach secular subjects, and they're being paid more to do so. So supposedly better teachers will teach those classes. Where this one fails is whether it fosters excessive entanglement between government and religion. So if we were in class, I would say, raise your hand if you've been to a private Christian school. And I always raise my hand. I've attended a private Christian school. And the question is there a course in a private school that is not religious? Well, not usually, right? You are going to have prayer. You are going to have concepts linked to Christian concepts. And you are going to have talk about religion in almost every single class period. So if you are learning about science, certainly if you're learning or reading anything about evolution, the creation story is going to come up. That's kind of an obvious one. But really, in my experience going to a Christian school, one semester for English, we read the Bible as our text. In math, we would talk about God's plan and God's perfect creation. In PE, we would talk about godly virtues and, concerning hygiene and athletics and things like that. So really in a private school, there's no guarantee that any subject is secular. And so the problem would be that the government would have to monitor what was being taught. And that provides too much of an excessive entanglement between government and religion. And I like to think that, I like to imagine that in order for only secular subjects to get subsidization, there would have to be a government official in every single classroom with a stopwatch clicking on and off every time they talked about God and clicking it back on when the secular subject resumed. And so obviously that would be excessive entanglement. However, if this was on an exam and you said it violated any of these three prongs, I would have to say, if you had good reasoning, that would be correct. Does it have a secular purpose? Well, not really, because 99% of private schools, at least in the Southeast, are going to be religious and they're going to be Christian. So it seems like it's a way to subsidize the Christian religion. And does it have a predominantly secular effect? You may have thought of the answer to number 3 and applied it to number 2. No, it's not going to have a secular effect. They're going to be paying teachers teaching Christianity to students at Christian schools about subjects that are both secular and Christian. And so really, it just doesn't pass the Lemon test. Now, if you did say it passed the Lemon test on the exam, I would need you to go through 1, 2, and 3 and explain why it actually passes. Don't just write yes and hope for the best, but actually explain why each one you believe is wrong. So on the upcoming exam, you'll need to pick a prong and say why it fails, or go through all 3 and say why it passes. Another example is having the 10 Commandments on court lawns or legislative lawns and things like that. So it's on government property and putting up the 10 Commandments. And a lot of people feel really strongly about this. When I lived in Oklahoma, there was a big 10 Commandments at the Oklahoma Supreme Court. And one guy kept just running it over, and they kept bringing it back up and he'd run it over, or one guy and another person. But they really, there was a really contentious. And so the question is, does that pass the lemon test? Does it have a secular purpose? Well, the government usually says the secular purpose is that this is the foundation of laws in the United States. And so it's really just an expression of the beginning of our legal system. Does it have a secular effect? You can, I don't think so. And does it foster excessive entanglement between government and religion? Really, usually courts decide that it violates number one and number two. It doesn't have a secular purpose, because it is saying that Christianity is the foundation of our laws, while there are lots of other legal traditions that we follow. And it doesn't really have a predominantly secular effect for the court to say, here's Christian laws and this is what you should follow. However, if states and counties and things like that decide to put other monuments up that respect other legal and religious traditions, then that starts to become more of a memorialization of legal traditions on the whole, and not pushing one religion over another, which is the establishment of religion. So we also have the religious freedom to exercise our religious freedom. It distinguishes between belief and action. So you can believe whatever you want, but there are some actions that are prohibited. And the Congress and state legislatures can regulate the time, place, and manner of the actions that you are exercising your religious freedom. So, for example, if your religion dictates that you slaughter a goat, for example, the government can regulate the time, place, and manner of that action. I can't go over into my cul-de-sac and slaughter the goat without the permission of my neighbors and without the permission of government, and on public property slaughter a goat. Instead, I might need to get some kind of license. I might need to go to a certain place that they've deemed it sanitary to do that. And I might need to go to a place where it wouldn't horrify public passersby in order to exercise my religion. And so the time, the place, and the manner can be regulated concerning freedom of exercise. So I don't think we'll go over this one today. My apologies. But so the test for freedom of exercise is the Sherbert test. The law must pose a substantial burden on the free exercise of religion. So that has to be true. When you're saying the government is prohibiting me from freely exercising my religion, the person who's saying that must show that the law poses a substantial burden on his or her free exercise of religion, and that person must hold a sincere belief in that religion. If both of those above are true, then the government must show a compelling interest in regulating the action. And actually, I am going to go back and do this example. This example was before the Sherbert test was actually utilized, but it's an interesting case, and it came up in California in the 1800s. And what was happening was a Chinese immigrant had been imprisoned, and his hair was cut because of the rules that prisoners had to have uniformity, and for hygiene reasons, they all had to have close cropped hair. But his hair was grown out into what was called a queue, because at the time, the Chinese national religion dictated that that was how you showed religious reverence, and essentially that their version of heaven was going to be, you were going to need to maintain this queue in order to have, eternal happiness after death, or eternal peace after death. And so they cut it in prison, even though he said it's part of my religion. They cut it, and so he sued. And so my question for you was, would that pass the Sherbert test? Did the law pose a substantial burden on the free exercise of religion? Yeah, probably, if he believes he's going to be judged by the peers in his religious community, judged by his God, judged by any kind of spiritual leaders for not having maintained the hair. then it is a substantial burden. And does this person hold a sincere belief? Yes, he did demonstrate he had a sincere belief in this religion. So if those are both true, we're going to say they are. Was the government's interest compelling to regulate this action? So the government said that it was for two reasons: for hygiene and to promote uniformity among prisoners. So those are both good reasons, but were they compelling? And the court ruled no. And that's what the Sherbert test would also say if it had been applied. No. And there are a few specific details that I didn't give you at the beginning that explain why this is not a compelling interest. Number one, the man who had his hair cut off was not convicted of a crime yet. He was merely arrested for a crime. Number two, the crime he was arrested for was living with too many people at the same time, which violated a California state law. Well, that law was meant to harm and give reason to arrest Chinese immigrants at the time who were impoverished and living in many together. And laws still today that prevent too many people from living together are to discriminate against immigrants living together. And one more group, guess who? College students from living too many together at a time. And so the court did rule that that failed the Sherbert test and that it would in the future. So here's your turn to take some time to pause this after I explain the story to you and decide what you think. A Seventh-day Adventist was fired when her company started a 6-day work week because she refused to work on Saturday because of her religious reasons. So Seventh-day Adventists, literally, what part of their religion that broke off from Protestantism was because the Sabbath is observed on Saturday and not Sunday. So then she was denied unemployment benefits. So this is where the government comes in, because her refusal to work on Saturday constituted a failure without good cause to accept available work. I sort of give it away with that third sentence here, but you can go back to the Sherbert test. Does the law pose a substantial burden on the free exercise of religion? Yes, because she had to work on a day that she considered holy. Did the person hold a sincere belief? Yes, she established that she had a sincere belief. So was the government's interest in not giving unemployment benefits because she refused to work on Saturday a compelling reason? And the court ruled ultimately that it was not. You could argue either way, that if somebody refuses to work for an entire day, maybe they should be denied unemployment benefits. But as I gave away here on this slide, at the time under South Carolina law where she was suing, employers were not allowed to require employees to work on Sunday. So it was discriminating against Seventh-day Adventists and others who observe a Saturday Sabbath while prioritizing those who observe a Sunday Sabbath. And so therefore it failed the freedom of exercise. That is all I have for this video. Thank you for your time and attention. I will be posting another video soon that talks about freedom of speech. And it will be a tit shorter than this one, as this one had so much information about these tests. Please remember that I will ask about these tests on the exam, so practice, practice, practice. Have a good day.